I'm firearms attorney Gilbert Ambler, and I'm back today to talk about the concept that we might see a circuit split develop on assault weapons bans, And why is it so critical that a circuit split might develop? Well, thus far, the United States Supreme Court has declined to take an assault weapons ban case, and that means that all the anti-gun circuits have been upholding them. That's right. You've seen the Second Circuit, the Fourth Circuit, the Seventh Circuit, the Ninth Circuit, all of these courts saying it is constitutional to ban wide classes of firearms that we think are too dangerous. And of course, we believe that's contrary to precedent. We believe it's contrary to United States Supreme Court cases. We believe it's dangerous. And more importantly, we believe it's something the Supreme Court needs to smack the lower courts down on. And of course, this is on the eve of, in the wake of the United States Supreme Court accepting another gun case. They've taken the Wolfford case, and I am happy they are taking the Wolfford case. I'm just not as overjoyed as you might expect, because although the Wolfford case is important, it's a sensitive places type case, and we should talk about it for just a second. The Wolfford case out of the Ninth Circuit, of course, a Hawaii ban, and Hawaii said that the default rule, even if you have a permit to carry, is that you cannot carry on private property without the consent of the landowners, without the consent of the property owners. And so they flipped the default from you can carry on private property to the default being in Hawaii, you cannot carry on private property unless you get explicit permission. And the Ninth Circuit said, we don't have a problem with that. That decision from the Ninth Circuit created a circuit split from even courts like the Second Circuit, which again, sitting in New York, is not a friendly gun rights circuit. But the Second Circuit even said, you can't do that. And so now we have different rules for different parts of the country. And as soon as we have different rules for different parts of the country, where something is unconstitutional to do in the Second Circuit, but constitutional to do in the Ninth Circuit, we've got a situation where the Supreme Court is way more likely to take the case, because the Supreme Court does not want inconsistencies where something is illegal in one part of the country and unconstitutional in the other part of the country because the courts can't agree. We're going to talk about how this could arise for assault weapons today. But as always, before we dive into this, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. Now, I just referenced all those circuits out there that have upheld assault weapons bans. And this is, of course, I talked about this in a video a couple weeks ago, in election season here in Virginia. Very scary for Virginians, because in this coming November election, assault weapons bans are, well, not literally on the ballot, they're on the ballot, because if the election goes the wrong way, we are very likely to see an assault weapons ban. And the Fourth Circuit, where Virginia sits, has already said that's okay, which means there's not a viable Second Amendment challenge to that. Although I believe it would be unconstitutional, the Fourth Circuit's already decided that issue, and the United States Supreme Court declined to take the case. And in declining to take the case, Justice Kavanaugh did say, hey, I think we need to take one of these cases soon, but they haven't done it yet, and that means it's still good law. So what we're looking for is that critical circuit split, because once we see that, like the Wolfford case out of Hawaii, we have a much greater likelihood that the Supreme Court will have appetite to take up and decide one of these cases. So where might a circuit split arise? The first place that we might see one, and this is the sort of lead-off route that we're looking for, is maybe the Third Circuit. Now, the Third Circuit has not traditionally been thought of as a pro-gun circuit, but we've seen some decent opinions coming out of the Third Circuit lately. We've seen the Range case come out of the Third Circuit. The Range case, of course, where the Third Circuit decided it was unconstitutional as applied to a particular felon for that felon to be prevented from possessing firearms. We've also seen the Lara case. The Lara case involved Pennsylvania's ban on young adults, 18 to 20-year-olds, open carrying firearms during a state of emergency. Another one where the Third Circuit said you can't do that. Young adults have the right to open carry firearms even during the state of an emergency. So we've seen these pro-gun decisions coming down out of the Third Circuit, which makes it especially interesting because we have the Cheeseman case going on right now. Now, the Cheeseman case came up out of New Jersey's assault weapons and large capacity magazine ban. And the district court judge there decided that it was unconstitutional to ban assault weapons with respect to the AR-15 inside the home for self-defense. Now, that is a over the top carving up of what was said in Heller and Brune to reach a partially correct result. I agree that it's unconstitutional to restrict AR-15s inside the home for self-defense. I would disagree, however, to the extent that it's also unconstitutional to restrict all the other assault weapons, and there shouldn't be no distinction between inside the home and outside of the home and for self-defense versus other lawful purposes. Additionally, that judge said totally legal, totally constitutional to restrict large capacity magazines. Goes up to the Third Circuit Court of Appeals. Third Circuit Court of Appeals does something interesting. They decide sua sponte, meaning on the court's own accord without anybody asking them to do this, they decide they're going to rehear this case en banc, meaning the entire Third Circuit Court of Appeals is going to hear this. In the Third Circuit, there is a chance we could get a pro-gun decision striking down New Jersey's assault weapons ban. If that happens, good news. We would then have a circuit split between places like the Fourth Circuit and the Third Circuit, and much more likelihood that the Supreme Court would take an assault weapons ban appeal. On the flip side, if the Third Circuit goes the wrong direction, you start to run out of options because you've got all the courts and the jurisdictions that have not so great states that are going to pass these, that have upheld them, right? So we know that the Seventh Circuit sitting in Illinois is not going to have a problem with assault weapons bans. Same for the Ninth Circuit, same for the Second Circuit. Where else could and then on the flip side of things, in the Fifth Circuit, you're unlikely to see Texas or Louisiana or Mississippi pass assault weapons restrictions. And if the state never passes anything, then there's never any litigation over it. So no opportunity for a good decision coming from the Fifth Circuit to create a split. So where else could a split develop? Well, we've got our eyes on Minnesota. Not that I want to see assault weapons bans come from any state, but Minnesota sits in the Eighth Circuit. And right now, Minnesota lawmakers are crying for a special session to ban assault weapons. And if they do this at the request of people like Tim Walz, the Eighth Circuit might be another jurisdiction that could potentially knock one of these bans down. The Eighth Circuit has had good rulings on things like the pistol brace rule and on young adults and their right to possess firearms and to acquire firearms and to carry firearms. And so the Eighth Circuit, like the Third Circuit, not traditionally a super pro-gun circuit, but also not a bad circuit, meaning that if Minnesota steps in it and bans these weapons, there will be a challenge running up through the Eighth Circuit and the potential for a circuit split. As I said, I'm not wishing for any Minnesota viewers out there. I am not wishing that you have this to deal with, but if you do have to deal with it, maybe we get that circuit split, which might entice the Supreme Court to take up one of these cases and strike down assault weapons bans for the entire country, something that I believe they need to do, and something that gun owners in a lot of those anti-gun jurisdictions that are already living under such bans probably hope for. If you enjoyed this content, go ahead, hit that subscribe button for us. Until next time.